Hey everybody, Todd Basil here, and welcome to another episode of 2-Minute Tech Law Tips, digestible bites for tech companies and investors. So this week we're going to continue talking about data and subscription software, and in particular how the parties might go about carving up ownership and other rights in the data amongst themselves. Now, to do this, we're going to walk through an example where a consumer apparel company wants to use a digital marketing company's software to help improve its marketing practices and success. So with that framework in mind, let's break this down from a data perspective. We'll start with the easy ones. Generally speaking, the parties will likely agree that each party owns its respective data contributions. So here, the consumer apparel company is going to probably own that business data that it uploads to the platform, and the digital marketing company is going to own the software platform itself, as well as the underlying algorithms and data sets. There are two situations where I see things tend to get quite a bit trickier. One is where one party wants to use the other party's data for a purpose that doesn't directly benefit the other party. The other situation is where data is generated using both parties' data contributions. Now, there's no real rule of thumb here. It comes down to negotiations amongst the parties. But one solution you'll often see is, hey, one party will own that information, but has to license it to the other party under certain conditions. This allows both parties to use the information for their respective purposes, but it also serves to protect the other party's confidential information in the process. Now, the balancing act here is obviously crafting those licenses in a way that maintains a workable relationship. Restrictions you'll often see is, hey, yeah, you can use this, but you can only use it internally. You can't share it with anybody, especially any of our competitors. You might also see in this situation the apparel company saying, yeah, you can use my business data with other companies, but look, it's got to be de-identified. It's way too sensitive for them to know that's our pricing, that's our customer demographic, and things of that nature. So lastly, the parties should consider what's going to happen to these rights after they part ways. This is something that I see overlooked all too often, and it's absolutely critical, because if you don't hash this out, there's a good chance that those licenses we spoke of might just go poof upon termination, at which point the reports you thought you would be able to continue to use might not be able to use them. The business data that the digital marketing company thought they could continue to use from the apparel company might not be able to use that either. So with that, we'll go ahead and wrap up. Please tune in next week for another 2-Minute Tech Law Tip. Take care.